Judgment in the appeal, Agbaje and Akinnoye-Agbaje.
Lord Collins is unable to be present, so Lady Hale will give the judgment of the court.
Part 3 of the Matrimonial and Family Proceedings Act 1984 gives courts in England and Wales the power to award financial relief after a couple have been divorced abroad. They can do so to supplement the award made in the foreign court or where no award has been made at all. In this case, the couple had strong connections both with this country and with Nigeria and were divorced in Nigeria. The judge in the High Court in England made an award to enable the wife to continue living in this country, as she has done for some time. The Court of Appeal set aside that award and gave her nothing. Today, the Supreme Court unanimously allows her appeal and restores the order of the judge. The judgment of the court, given by Lord Collins, gives guidance on the principles which should guide the court's approach to such cases in the future.
Judgment in the appeal, RTS Flexible Systems against Molkerei Alois Müller, Gmbh.
Lord Clarke will give the judgment of the court.
In this appeal, the Supreme Court considered whether there was a binding contract between the parties. The parties originally intended that there would be a signed document setting out the terms of the contract in considerable detail. Work, however, began before the terms were finalised. It was initially agreed that the work would be done under an agreement set out in a letter of intent. The question was whether, when work continued after the letter of intent contract expired, it was done pursuant to a contract, and if so, on what terms. The court considered the principles relevant in such a case, observing that the moral of the story was not to start work without agreeing the terms on which the work was to be carried out. The judge at first instance, Mr. Justice Christopher Clarke, had held that there was a contract between the parties, but on limited terms. The Court of Appeal held that there was no contract between the parties. This court reached a different conclusion from both the judge and the Court of Appeal. It held that there was a contract between the parties, but on much more detailed terms than those found by the judge. It held, in essence, one, that the parties reached a binding agreement on or about 25th August 2005 on the terms agreed on or before the 5th July, namely as set out in the detailed draft agreement exchanged between the parties as varied on the 25th August, and 2, that the binding agreement was not subject to contract or to the terms of clause 48 of the draft contract. The court orders that 1, the appeal be allowed, and 2, the parties make A, written submissions on the precise form of the order, including the precise formulation of the declarations to be made and on costs by 31st March, and B, if so advised, written submissions in reply by the 13th of April.